Maloney, and I am the Northeast Regional Coordinator for Students for Life of America. That means I run New York and New Jersey. So if you're from either of those states, please introduce me to yourself by the end of this talk. We have a special guest with us today. We have Professor Dwight Duncan. He is a UMass law professor, and he's going to discuss the history of abortion law. Professor Duncan has written numerous articles on legal, moral, and religious issues. He has argued several cases before the Massachusetts Supreme Judicial Court and the Appeals Court, and has written briefs for the U.S. Supreme Court. He is a member of the Massachusetts and Washington, D.C. bars, the board of directors of the Pro-Life Legal Defense Fund, and serves on the board of advisors of Massachusetts Citizens for Life. So put your hands together for Professor Dwight Duncan.
Thank you very much. Well, I'm supposed to cover the history of abortion law, I guess. So this is everything you wanted to know about abortion law, but were afraid to ask, I guess, or something like that. I suppose the simplest thing is to try to start with Roe versus Wade. Prior to Roe versus Wade, almost every state in the country had quite restrictive abortion laws. And in the late 60s, actually, there was a movement afoot to kind of reform or liberalize abortion restrictions, and this advanced somewhat in a couple of states, in New York under Governor Rockefeller, and actually, oddly enough, in California under Governor Ronald Reagan. So basically, abortion was pretty much illegal throughout the country in the early 1970s when the Roe versus Wade case came along. And what that represented was a constitutional challenge to abortion prohibitions, or more generally to laws that restricted abortion. And the challenge was brought under the 14th Amendment's due process clause, right? The 14th Amendment basically says that no state shall deprive a person of life, liberty, or property without due process of law. So the argument was, I think it's a kind of strange argument in a way, that the ability of a woman to terminate her pregnancy, right, to kill the unborn child, was part of the liberty protected by under the due process clause of the 14th Amendment. Now, normally when we're talking about due process, we're talking about procedural due process. In other words, before the government can take away your life or your liberty or your property, it has to basically provide notice and a hearing and kind of give you reasons, and then it can kill you, right? Or then it can take away your property, right? Or sentence you to jail time. But it turns out that the Supreme Court has developed over the years cases along the lines of what's called substantive due process, right? That there are certain things that the government basically cannot do to you, period, right? Oddly enough, the origins of substantive due process are quite suspect. That is, the first time the Supreme Court used this substantive due process argument was in 1857 in the notorious case of Dred Scott versus Sanford, right, where a slave who had been brought into the free state of from Missouri, which was a slave state, had been brought into the free state of Illinois and then into the free federal territories of Minnesota, essentially was suing in the federal court in Missouri for his freedom, right? And what happened is that the U.S. Supreme Court, in a 7-2 decision, just like Roe v. Wade was 7-2, yes?
Wasn't that the one slave that was of an army officer at Fort Snelling?
Yeah, there's a history behind the whole thing, but yeah. So in any case, he was suing for his freedom. In some ways, from the perspective of legal hindsight, his mistake was voluntarily returning with his master, to Missouri, the slave state. Okay, but his claim was that he had been freed by virtue of being brought voluntarily into a free state or free federal territory. And what the U.S. Supreme Court decided 7-2 in 1856, on March 7th, 1857, was that basically, at that time, there wasn't a 14th Amendment. The 14th Amendment was passed after the Civil War, right, in 1868. But what there was the Fifth Amendment, which prohibited the federal government from taking away your life, liberty, or property without due process of law. And so what Chief Justice Roger Brooke Taney decided for the majority of the court was that owning human beings, owning slaves, was constitutionally protected property, and therefore the federal government, through the Missouri Compromise of 1820, had no right to take away the liberty and the property of slave owners, right? And therefore, Dred Scott was not a citizen, and therefore he could not bring a case in federal court. So basically, this was the first use of substantive due process, right? That basically to enshrine slaveholding as a constitutionally protected right? And legislatures could not abolish it or get rid of it. And it actually took both the Civil War and the 13th Amendment to formally abolish slavery, right, in the United States, to overturn Dred Scott. Now, fast forward to 1973, in Roe versus Wade, the Supreme Court again decided 7-2 that substantively protected liberty under the Due Process Clause, right? That substantive due process protected the right of a woman to get an abortion, to terminate her pregnancy, okay? And we'll talk about the qualifications on this. But once again, the court, and this time though, the court said not just that the unborn child was not a citizen, which is what Dred Scott had said, right? That is, even Dred Scott recognized that slaves were persons, right? That African Americans were persons, but just not citizens, and therefore couldn't bring a claim in federal court, and furthermore, the attempt of the federal government to abolish slavery north of a certain parallel was unconstitutional, right? So Roe v. Wade, basically, the first question Roe v. Wade had to deal with, right, was this question about the personhood, right, legal personhood. It turns out that a legal person is not, while in general natural persons are legal persons, turns out there are entities, right, institutions that are also considered legal persons, right? So corporations are a classic instance of this, right? Corporations are legal persons. That is, they can sue and be sued, right? They can own property, whatever, so they have aspects of legal personhood, right? So the first question Roe versus Wade had to deal with was the question of whether unborn children are persons within the meaning of the Constitution. Because if they were, right, then there's a strong argument that not just that abortion prohibitions were constitutional, but that they were required by the Constitution in order to enforce equal protection of the laws, right? In other words, if the unborn are persons the way you and I are persons, right, the way born people are persons, then the state would have the duty of protecting their life the way it protects everybody else's life, right? So what the court said was that if we examine the use of the word person in the Constitution, nowhere is there evidence, right, that the framers of the constitutional language envisioned that unborn human beings would qualify as persons. Although the 14th Amendment does begin, in Article 1 of the 14th Amendment, it begins with the statement, all persons born or naturalized in the United States are citizens of the United States and of the state in which they reside, right? So the 14th Amendment itself begins with a proclamation that born persons are citizens of both the United States and the state in which they reside. Clearly, this was intended to also reverse Dred Scott, right, and say that you are, not just are you a citizen if you're born here, right, birth citizenship, but if you're naturalized, you're a citizen, and not just of the United States, federal citizenship, but of the state in which you reside, right? Now, the fact that it talks about all persons born, right, assumes that there are persons that are, there are also a category of persons that are unborn, right, or not born, right, I think. So there's also an argument, even though the Supreme Court did not accept this argument, there's also an argument, a kind of textual argument, that the word person, right, in addition to encompassing corporations, as the Supreme Court held in the 19th century, it also encompasses unborn human beings, right? In which case, there would be no good constitutional argument against abortion prohibition, right? But so what the court said, no, we look at person, and we, as far as we're concerned, every time the Constitution talks about, apportionment, right, counting persons for purposes of allocating electoral districts, it assumes that we're talking about born persons, right? And so, therefore, basically the fetus is legally nothing, right? It's a little bit like the slave, right, was legally nothing. It's like, if we want to talk, if there's a battle, right, or a legal fight between the slave master and the slave, right, it's like the slave doesn't count because he's not a citizen, right? He doesn't have any legal rights. If we want to talk about legal rights, they're all on one side. They're all the slave owners. Well, similarly, the Supreme Court did the same thing in Roe versus Wade, again by 7-2, right, and said that, oh, actually, if there's a situation in which a woman wants an abortion, right, and so her interests are pitted against those of her unborn child, the fetus is nothing. It's not a person, right? So the only person we can think about is the woman, right? And then the court went on and said, does liberty within the meaning of the 14th Amendment encompass the right of a woman to terminate her pregnancy? One of the things Roe did was use a lot of euphemisms, right, so that you wouldn't just see the bloody mess that abortion actually is. It's all right to choose, right to privacy, right, this kind of abstract language, right? So similarly, terminate a pregnancy, right, rather than kill a child, right, an unborn child. But what the court said was that and it's a famous passage, actually, in Roe versus Wade, where Justice Blackmun, for the majority, says that wherever we find this right to liberty in the Constitution, whether it be in the 9th Amendment's reservation of certain rights to the people, or, as we think it is, in the 14th Amendment's liberty provision of the Due Process Clause, wherever it is, right, it's broad enough to encompass a woman's decision to terminate her pregnancy. So in other words, the court interpreted liberty in this very broad, expansive kind of way, right? And say, well, obviously a woman's decision to get an abortion, particularly in consultation with her physician, right, that's protected under constitutional liberty, right? And therefore, state laws that prohibit abortion are unconstitutional. Principle. Well, what I think I just wanted to draw your attention to an interesting feature of Roe, of the legal approach, right, that the court uses, the approach to constitutional interpretation, right, which is the court said, look, we're going to examine the word person in a very kind of literal, restrictive way. But then when it comes to the term liberty, all of a sudden, we're not going to view it in a kind of narrow, legal, restrictive way. We're going to view it as just anything that interferes with what you want to do, right? And so obviously if that's the way you're going to approach it, right, then the fetus is nothing and the right to abortion is enshrined in the Constitution. But the fact of the matter is this methodology is totally arbitrary. Totally arbitrary, right? Because they could have said, I think they should have done is approach, use the same methodology on each term, that is person and liberty, right? So if you want to use a restrictive historical kind of understanding, then okay, if the person doesn't include the unborn, neither does liberty encompass abortion, because at the time that the 14th Amendment was written and ratified, it's the late 1860s, by 1868, almost all states had criminal statutes prohibiting abortion, right? So the idea that somehow liberty, within the meaning of the Constitution, encompassed the right to abortion is a non-starter, right? I mean, just as laws prohibiting murder, right? In some ways, obviously they restrict a person's liberty, right? I mean, if you want to kill somebody, the law says you can't do that, right? And nobody would say, well, that's a constitutionally protected liberty interest, right? Because it's stopping me from doing something I really want to do, right? Okay, so I'm saying by similar sort of approach, liberty within the meaning of the Constitution really doesn't encompass abortion. At least it didn't in 1868, right? So part of this has to do with the sort of arbitrary methodology that the court uses in Roe versus Wade. The other thing that I object to, in addition to the sort of use of euphemism throughout the opinion, it's that the court uses language in general to describe what it's doing that is quite misleading. Because what it says is that prior to viability, right, prior to the more or less this 6 month of pregnancy, right, where the unborn fetus is able to survive outside the mother's womb. Prior to that time, states may not restrict a woman's ability to terminate a pregnancy. Actually, Roe imposed a trimester framework, which I'll mention. But after that, at viability, right, the states can limit it or even prohibit abortion, provided that the woman's health is not life or health is not adversely affected. Right? That seems to indicate, right, that somehow late-term abortions, third trimester abortions, could be made illegal, right? But I'm saying that's terribly misleading, because the companion case of Doe versus Bolton, right? There were two cases. And one of the interesting things about both these cases is that both of the women, right, Jane Roe, Norma Weddington, and Norma McCorvey, and she was represented by Sarah Weddington of the ACLU in Texas, and Jane Doe in the Doe versus Bolton case. Both of these women basically misrepresented what had happened, right? I mean, the basic idea was they both claimed to have been raped. That wasn't the case, right? And the other thing that's happened is both these plaintiffs of these cases, right, these landmark decisions that established a constitutional right to abortion, both of these women ended up very strong pro-lifers, right? Which is kind of an interesting thing. And in fact, Jane Roe, Norma McCorvey, actually gave birth. Now, she didn't get the abortion, right, that she sued for and that the Supreme Court used to say everybody has this right. She didn't get the abortion. She had a child, right, who's now a woman, right? I mean, okay, so it's misleading because Doe versus Bolton said, okay, how do we understand health, the woman's health, right? Because the rule is states may prohibit abortion in the third trimester except when necessary to preserve the woman's health. And what the court said was health has to be understood, like liberty, has to be understood very broadly, as encompassing not just physical health issues, right, but psychological, emotional, financial, and familial factors. Okay? Well, of course, what that means is, as a practical matter, right, up until the moment of live birth, throughout the pregnancy, right, any woman who really wants to get an abortion can get one, right? Because you just say, I can't afford it, my family's against it, right? I can't handle it, right? I mean, just psychologically, I can't handle it. Right? And therefore, you qualify for that. You fit within the health exception. So, in fact, states cannot ban abortion in the third trimester. So this is where I say, I think, in fact, the opinion is extremely misleading, right? It had the effect, though, at the time, you know, Chief Justice Warren Burger, joined the majority opinion, but he writes a separate concurrence saying that this is because his understanding of the holding is that this does not encompass a right to abortion on demand, right? Later, in a subsequent abortion case before the U.S. Supreme Court, Burger joins the dissent on abortion, saying that he was wrong about his understanding of Roe versus Wade. That in fact it did entail a right to abortion on demand throughout the pregnancy. All right, as I've said, Roe v. Wade established a trimester framework for how courts, so it established the idea that abortion is a constitutional right. So overnight, abortion went from being a crime in at least 48 of the 50 states to being a constitutional right. I mean, that's an incredible overnight change, right? I mean, it's an amazing, a breathtaking kind of change, right? All of a sudden, in other words, that the democratic process, right, whereby laws have been enacted in all the states, right, that's totally overridden by this decision of 7 judges on the U.S. Supreme Court, right? In other words, the democratic process doesn't matter. Politics doesn't matter. This is no longer a subject that is amenable to political compromise, right? Any more than Dred Scott said that slavery was amenable to political compromise. No compromise. Slavery's embedded in the Constitution, right? It took a civil war and several amendments to undo that, or try to undo it, right? So Roe establishes this constitutional right to abortion, but it basically distinguishes between 3 trimesters, right? Like saying abortion, like Gaul, is divided into 3 parts. You know, the famous beginning of Caesar's Gallic Wars, right? First 3 months, the court says, well, in the first 3 months, it turns out having an abortion is safer than delivering a child, and therefore, no regulation of abortion is appropriate in the first trimester, right? Nothing, right? No regulation. Second trimester, the state can regulate abortion, but only in the interests of the woman's health. Okay. In other words, again, the fetus doesn't count for anything. Okay. So in the second trimester, states could require, for example, that abortions be performed in licensed clinics or by medical doctors, right? But nothing to protect the life of what the court called the potential life of the fetus. Again, you know, potential life is one of these, you know, kind of wiggly terms because, of course, there's no question but the fetus is alive, right? It's alive. Right? Now, does it have potential life? Yes, obviously, because it's, you know, you and I are all former fetuses, right? I mean, so we're not all we could be, right? And when we were in the womb, we're probably not all we could be now, right? You all are young. I'm just saying. In that sense, we're potential life, right? We're not all we could be, right? But that doesn't mean that therefore there's no right to life, right? I mean, which is what the court in effect said. So in the first trimester, no regulation. Second trimester, regulation only in the interest of women's health. Third trimester, the court said, by then, the state's interest in the viable fetus becomes compelling. Notice the court talks about the state's interest, right? Becomes compelling, but as I said, it's not so compelling that the fetus's life interest can in any way trump the mother's health interest. So the fetus's life interest, no matter how compelling, how strong, cannot trump. That's a bad word now. Cannot winnow, beat out the mother's health interest, no matter how trivial, right? Yes.
So I'm interested with in reference to the law of minors, though.
Okay.
So a minor,
Right.
a teenage girl,
Mm-hmm.
would she have been considered a citizen?
Yeah, she's a citizen and a person, no question about it,
Or
right?
her parents have been considered especially for medical.
Right. Well, in generally speaking, right, minors are, under the control, legal guardianship of their parents, right?
Except in the case of abortion.
Well, except in the case of abortion, the general rule is that, you can have a mature minor, right? Or we'll talk about this because I'll talk about parental consent, parental notification laws. But so let me return to that, okay? But it's a very good question, right? So Roe establishes abortion as a constitutional right throughout the country, strikes down all these abortion laws, restrictive abortion laws, right? But of course, it generates a kind of backlash, right, that has been growing and growing and growing, right? And furthermore, I teach normally constitutional law, and what strikes me is that the whole judicial nomination process has been in effect poisoned by Roe versus Wade and these kinds of decisions. Actually, a couple years ago, Supreme Court did the same thing with gay marriage, right? It basically said gay marriage is a constitutional right, and therefore it doesn't matter what you think or what compromises the states might have reached on this matter. Those are all those are all unconstitutional. I'm saying it troubles me, right? The ability of sometimes just one judge to decide these issues. That's what happened with the gay marriage. Several years ago, it was Justice Kennedy's opinion that counts, right? Nobody else's opinion counts for anything. So these, whatever, the referenda, the various, legal compromises, all are overturned, right, overnight. So I'm just troubled by this because, how is that really compatible with a democratic system, right, in which everybody's vote is supposed to count, right? Everybody's view is supposed to count. And okay, we can lose in the political process, kind of you win some, you lose some, but it just seems to me it's easier to accept losing, right, if you've had your say in the public square and, and just you haven't convinced a majority of your, fellow citizens to kind of go with you, right? That's easier to accept than, well, Justice Kennedy disagrees with you, and, his opinion rules the country, right? So anyway, so I'm troubled by this, as a just constitution. Yes, I think if the Constitution clearly requires something, then obviously that issue is removed from politics. But in the case of abortion, or for that matter, even in the case of gay marriage, the Constitution doesn't say anything about those things, right, really? And like I say, I think if anything, the word person you know, in the Constitution should be understood broadly, right? If they're willing to view corporations as persons, why not unborn human beings, right? So, anyway. So that was, so it poisoned the judicial nomination process because everybody realizes, right, the real fight is on getting your person, your man or woman, person who agrees with you on the Supreme Court, right? So all hell breaks loose over virtually every judicial nomination, certainly to the Supreme Court, since Roe versus Wade. And my view is, what's wrong with this picture, right? It's like, I don't think being a judge should be that controversial, right? Because judges should decide the cases according to the constitutional laws, right? Without fear or favor, right? Fairly assessing the facts or whatever, you know. I'm saying, in most matters, the judge's political views or ideology or whatever, right? Philosophy shouldn't really count, right? It's like they're supposed to decide according to constitutional laws. But if the Constitution can mean whatever 5 judges say it means, right? In other words, if they can amend the Constitution by judicial fiat, by one vote, which is what's happened here, right, then that's a real problem, right? I think it's a real problem. Yes?
Can you talk more about Doe versus
Doe versus
Bolton?
Bolton. Well, I can't really say much about it other than say that it was decided the same day as Roe versus Wade, January 22nd, 1973. So we're talking about now 45 years ago, this Monday, right? And it dealt with the Texas abortion law. I'm sorry, the Georgia abortion law rather than the Texas abortion law. The Georgia abortion law was a more liberal, modern kind of law prohibiting abortions than the Texas one was, right? So it was a companion case. So that's why the court got into this health exception, right? Where it defined the broad reach of the health exception. Okay? And that's pretty much all I know. Yeah.
Talk about Casey versus Planned Parenthood.
Yeah, let me talk about that. That's a great question. Because one of the things that happened in the wake of Roe versus Wade was basically the issue of abortion became sort of politicized in the sense that the Democratic Party became the party of abortion and the Republican Party became the party of anti-abortion or pro-life. And so what happened is we elected a number of Republican presidents. And the platform of the Republican Party, right, was that, you know, they were dedicated to overturning Roe versus Wade. So by 1992, right, when I guess George H.W. Bush was still president, the Solicitor General on behalf of the United States government was arguing in the court, the Supreme Court, that Roe should be overturned. And since there was a majority of justices now on the Supreme Court who had been appointed by Republicans after Roe versus Wade, the expectation was, after almost 20 years, right, now we're 45 years later, that Roe could be overturned. And instead what happened is that 3 of the Republican appointees who had been appointed by Reagan or Bush banded together. It was basically Justice Sandra Day O'Connor, Justice Anthony Kennedy, and Justice David Souter, who had been appointed by Bush. The previous 2 had been appointed by Reagan. They decided to vote with the abortion side. So even though everybody, pretty much the nation, right, the pro-life side, we all were hoping that this would represent the overturning of Roe versus Wade. Instead, just the opposite happened. Planned Parenthood versus Casey affirmed what it called the central holding of Roe versus Wade, right? This right to an abortion prior to viability, and it reasserted this rule that after viability, states can prohibit abortion provided it doesn't affect the woman's health, but again, health understood broadly. So there was tremendous disappointment at the time, I think, among the pro-life community, feeling basically, we're never gonna, you know, because one of the things that the court did in Planned Parenthood versus Casey, engaged in this kind of bogus assessment of overturning constitutional precedent, right? It's like, and a lot of hand wringing, and more or less, the idea was when the court speaks, to decide issues on which Americans are divided, right? That it's up to the populace really to rise to the Supreme Court's, decision, and kind of a lot of bullshit, basically. I mean, sorry, but I mean, it was the most pompous, ridiculous decision. And because of course that same kind of reasoning could have been used with Dred Scott, right? It's like, okay, once the court decides a divided issue, right? That's it, right? It's up to you now to just take it, right? Accept it, right? And I'm saying, no. So Casey did get rid of the strict trimester scheme. That it said that states could regulate in the interests of the unborn child, even in the first trimester, right? So, for example, laws requiring informed consent for abortion, right? That a woman, before getting an abortion, be informed of what exactly is going on, right, with this process, and what the alternatives are. Right? Those laws, after Planned Parenthood versus Casey, were considered constitutional, right? And similarly, waiting periods of like 24-hour waiting periods. Right? Turns out, in a lot of states, if you buy a car, some serious kind of consumer purchase, right? The law gives you a sort of window of time to kind of reconsider, right? Because this is a significant decision, a significant investment, and you might have want to have buyer's remorse, Well, so I think the idea of the waiting period for an abortion was, this is actually a serious decision, right? It has consequences, obviously for the unborn child, but also for the woman, right, who undergoes the abortion, and therefore the idea that she should have to think about it, right? That's constitutional, right? So what Casey did, it basically said that for abortion regulations prior to viability, the rule is now states can regulate abortion, but not so as to unduly burden a woman's decision to get an abortion, or engage in a regulation that has as its purpose or effect placing a substantial obstacle in the way of a woman getting an abortion, right? So this undue burden, substantial obstacle. That's for regulations prior to viability. After viability, the rule is the same as in Roe about states can theoretically restrict it, but subject to a broad woman's health exception. Okay, so now there are a number of provisions of the Pennsylvania Abortion Control Act that were before the court in Planned Parenthood versus Casey, and the court upheld, the majority of the court upheld all of those provisions, like, for example, the informed consent 24-hour waiting period. There was also this provision for, I think it was two-parent consent, or maybe it was one-parent consent for abortion. But what you have to understand is these cases involving either parental consent or notification for one or two parents, right? Before a minor, a girl can, a woman under 18, right, can get an abortion. Those requirements have been upheld by the court only if there's also what's called a judicial bypass, right? Now, judicial bypass basically says that she doesn't have to get her she doesn't have to tell her parents, she doesn't have to get her parents' consent, right? She really doesn't want to, for whatever reason. And she can go into court, anonymously, and get court approval for getting an abortion without telling her parents. Now, I had this interesting experience in Massachusetts where Planned Parenthood, of course, I don't know, this is 20 years ago, brought a challenge to Massachusetts law, because Massachusetts actually had a lot of laws on the books regulating and restricting abortions that were never actually formally repealed, right? So to the extent they were still constitutional, they're valid. Well, Massachusetts used to be a strongly pro-life state. It's not anymore, sadly. But it required two-parent consent, right? But you had to get the consent, not just tell them, but you had to get their consent, from both parents. But the Massachusetts Supreme Judicial Court basically issued an order saying how these cases, these Mary Moe petitions, right, were to be handled by the courts. And what the court said was that the court that heard the petition from this girl who remains anonymous, the court was to grant her the permission to get an abortion, a legal abortion, either because she was a mature minor, right? That is, she was maybe though 15, she was sufficiently mature to be able to make medical decisions for herself, even though, in order to get a aspirin from the school nurse, you need your parents' consent, right? I mean, but the point is, either because she's a mature minor or because it's in her best interest. But the Supreme Court of Massachusetts said if any judge dares to deny this petition because the child is not a mature minor and an abortion is not actually in the child's best interest, that is the supreme mucky mucks on in the judiciary in our state, will reverse that order within hours, right? So what I'm saying is, in effect, in Massachusetts, the way parental consent laws operate is as a rubber stamp. In the case of this judicial bypass, it's a rubber stamp, right? It's a judicial rubber stamp. Now you can say, well, what's the value of that? And we litigated this with Planned Parenthood. What's interesting is, even though that's the case, still Planned Parenthood wanted to get this law off the books, to have it declared unconstitutional as a whole, right? And the reason was just having a parental consent law on the book, even with judicial bypass. The law, even though you don't really have to get your parents' consent, right? Because you can always go to court, and Planned Parenthood will provide a free attorney to bring you into court, right? And even sometimes across state lines into New Hampshire to get the abortion, right? Because New Hampshire didn't have a parental consent law. Just the fact that there's this requirement in the books, the law just doesn't only force you to do things you don't want to do, it also teaches, right? So it's quite clear just having a parental consent law on the books was basically driving the numbers of abortion, the abortion business down. Planned Parenthood didn't like having it even with the judicial bypass, right? Because most people would say, would I rather tell some judge, right, my situation, or would I rather tell my parents? Well, in almost all cases, right, the parents love the child, right, have the best interests of the child at heart, right, and I think most cases will encourage, having the child, not having the abortion. Although there have been some sad instances, right, of parents forcing, right, girls to get abortions. I mean, suppose this is another interesting aspect of sort of the legal regulation of abortions, because the one provision in Pennsylvania that the court said was unconstitutional in Planned Parenthood versus Casey was a provision of spousal notification, right? It basically said that unless there was an emergency, or unless, you were in an abusive relationship, you had to tell the presumptive father, right, your spouse or the boyfriend, you had to inform him that you were getting an abortion. This is a notification law, it's not a consent law, right? Because the court had previously said spousal consent laws are unconstitutional. In other words, which is interesting if you think about the consequences of that. It means that if a woman decides to get an abortion, it's her sole choice, right? And you would think that therefore, since it all depends on the woman's choice at this point, right, whether to have the child or not, that somehow the father, right, may or may not be married to the woman. The father, if she decides to have the baby, would somehow, if it's her sole decision at that point, right? Why does he have to pay child support, right? And because he doesn't have any say on this, right, at all, right? Even though it's his child also, right? And obviously, men and women, when it comes to pregnancy, are not similarly situated, right? I mean, clearly, right? The burden on the woman is much, 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 much greater than the burden on the man. I think. Hopefully, you all know about the birds and the bees and stuff like that. Anyway, but what the court decided in Planned Parenthood versus Casey was that this spousal notification law was an undue burden or substantial obstacle on women getting an abortion. Now, of course, in order to do that, the court had to depart from its usual rule in examining whether a law on its face is constitutional, right? Because normally, in order to have a law declared unconstitutional on its face, as opposed to as applied to these particular plaintiffs or defendants, right, to have it declared unconstitutional on its face, it has to not be valid in the majority, of instances. But clearly, spousal notifications for abortion, in most instances, right, women can tell their husbands, boyfriends, whatever, right, the father, about it, and, the guy is not going to be an ogre, and sort of lock the woman in a room, or I don't know what. I mean, in most cases, right? But there are going to be some cases where that's probably true, but it's a very small minority of cases, right? And that's what the court said. The court departed from its usual rule, of looking at the generality of cases as facial challenges, and here it looked at as to that particular group, that particular small group of women for whom this would make a significant difference, right? And said as to them, it was an undue burden, a substantial obstacle in the way of getting an abortion. Now, I'm taking a step back from this. Here's what I say about that, about striking down spousal notification laws. As I said a few minutes ago, right, I think you have to understand one of the functions of the law is not simply to force somebody to do something, or send them to jail if they don't, and all that stuff. Yeah. But it's also to instruct as to how to live, how we want to structure our lives together, right? And signal that the teaching that emerges from striking down spousal notification provisions is not just that the man doesn't count at all in the issue, but it's that he doesn't even have a right to know about it, right? And so what this means, the signal this sends is, I think, it's okay to sleep with someone you can't even talk to, right? And yes, that happens, right? But I'm just saying the law should express, I think, encourages us to, our better selves. Am I out of time?
I think just. Oh, you're right at 5 minutes.
Okay, I'm sorry. I apologize. I should have had more time for questions. I wanted to tell you the last thing I wanted to say. This is kind of a plug. Last Friday, a week ago, on January 12th, I filed an amicus brief in the U.S. Supreme Court in an important case this term called Nibbler versus Xavier Becerra. It's a case out of California. California has a law that requires crisis pregnancy centers, which are basically pro-life, to advertise for abortions, right? And this law has been crazily considered constitutional by the Federal District Court in California and the Ninth Circuit Court of Appeals, which is the federal appeals court that is most often reversed by the Supreme Court. The fact that the Supreme Court took this case, I think the handwriting is on the wall that they're going to rule our direction, right? They're going to say this violates freedom of speech, because this is compelled speech. So I represented a number of pro-life groups and individuals, including Eleanor McCullen, who was the successful plaintiff in challenging before the Supreme Court the Massachusetts buffer zone law a few years ago, and got a unanimous decision saying it was unconstitutional in violation of the freedom of speech, right? So I filed, and my co-counsel was Professor Mary Ann Glennon of Harvard Law School. And the nice thing is, you know, it's like, this is your generation, not mine. It's like, this brief was actually written by 9 pro-life Harvard Law students who essentially gave up their Christmas break. You know, they got out of exams and immediately started working on this. It was entirely written by them. I didn't have to like change a comma in getting it to the Supreme Court printer, right? But of course, you know, like, law professors are great at taking credit for other people's work, but I'm just, and I can understand why maybe some of these students, and I'm you know, in consultation with, because I want them to get credit, right, for this, because it's a wonderful piece of work, much better than I could have ever done. But and it's short. The other thing is it's a brief, which is always good, you know. In other words, get to the point. It's not quite a tweet, but I'm just saying it's like, you know, it's a legal thing. Yeah, question.
Would you say Bucky Bell might have something to do with Roe v. Wade?
Yeah, well, Buck v. Bell, I mean, the thing is, Oliver Wendell Holmes, who wrote this decision, the 3 generations of imbeciles are enough. He had this dismissive view, this kind of Darwinian view of people, right, survival of the fittest. So yeah, I think, yes, it's an unfortunate thing in our jurisprudence. Yeah.
I think pro-life movement in general pins some hope to the idea of you elect the right president, you elect the right Congress, Senate, and if we get the right judges in, right, if we get another Neil Gorsuch, right, or another Antonin Scalia in place of one of the liberal justices, right, so then, you know, we have some hope of overturning Roe v. Wade. My impression is that even a conservative court would be hesitant to wade in and clearly overturn a major precedent while simultaneously deciding on a hugely controversial cultural question. What's your impression of how this?
Well, I think that may well be the case. Although I think it's possible. I mean, I certainly wouldn't have thought this, you know, in the '90s after Casey. After Casey, I thought we were stuck with Roe versus Wade forever. But I don't think so necessarily. But so it's possible. You know, but the other thing that I think is important for people to realize is that even overturning Roe versus Wade is not going to have necessarily a very dramatic effect, because in places like Massachusetts, you know, in other words, all it will say is that abortion restrictions are constitutional, but you still need a law, which has to go through the legislature, right? So if the politics and the, you know, is pro-abortion, nothing will change in Massachusetts, right? Abortion will be available on demand, and the public funds it in abortion, right? In Massachusetts, right? That is, poor people's abortions are paid for by our, you know, through state taxes, even though the federal rule is, you know, your federal taxes don't go to pay for abortions, right? For indigents. So I think we're time, isn't it? Yeah. Thank you for your